For those of you who watched the show yesterday night or followed events therefrom, you realize that we discussed the arrest of Honorable Obiamwa. And indeed, Article 117 came up, and if you followed it on myjoyonline.com, a story was put out on yesterday's discussion relative to that, flowing from the discussion that we had here. So, with your indulgence, I will read Article 117 of the 1992 Constitution, which has the subheading, immunity from service of process and arrest. And of course, for those of you who are lawyers or are interested in these matters, there's always be a debate as to whether the heading in itself is a signpost that leads us to the intendment behind the provision. The words are civil or criminal process coming from any court or place out of Parliament shall not be served on or executed in relation to the Speaker or member or the clerk to Parliament while he is on his way to, attending at, or returning from any proceedings of Parliament. Of course, under Part 3, Subpart 1 of the privileges and immunities, standing orders of Parliament, you will find further provisions which seek to break this down and make us understand how it is supposed to work out. You will not forget so soon that last year, when Honorable Atachia, as was reported, also was arrested at the premises of the court, the issue arose as to whether that arrest flouted this constitutional provision. And so we will tonight, I think that we are very privileged to have the majority leader in Parliament, Honorable Cletus Avoka, on my immediate left. Thank you for coming, sir.
Thank you very much.
And also the minority leader in Parliament, Honorable Osei Mensah Bonsu. Thank you for coming, sir.
Thank you for having me.
It's a very high-powered panel tonight, and that is the beauty of our democracy. Let's get to it right from the start, and then ask you, I don't know whether, when you're moderating a program where you have the majority leader and the minority leader, you should be careful as to who you may ask the first question. I wish I could actually flip a coin to determine who picks it. Because you know how our viewers can behave sometimes and say that you are not fair to this one or that one. And so I have a tough duty to do tonight. But let's begin with the clause. And I believe that in our country, we also give credence to the majority relative to the minority. So I hope Honorable Osei Mensah would allow me to begin with Honorable Cletus Avoka on that score, and that's not to take anything away from any side, and ask you, what in the first instance do you make of the meaning of this provision as I have read it, before we begin to relate it to the factual situations on the ground that have led to us putting together this show? What is 117 saying?
Well, there are three elements in the 117. And that one of them is that a member of Parliament or the Speaker of Parliament or the clerk, for that matter, should not be tampered with, should not be arrested or serve a process if he is on his way to Parliament. 2, attending at Parliament. And then 3, returning from any proceedings of Parliament. These 3, to all intents and purposes, are intended to ensure that a member of Parliament that we are focusing this evening is unfettered in his effort to get to Parliament while at work too, and while he is going home after parliamentary proceedings. So if you look at these 3, I think that the sky is the limit as to the privileges and immunities of a member of Parliament having regard to civil or criminal process. And that is a very serious challenge, particularly to law enforcement agents and to our courts who want to serve processes on the Speaker or a member of Parliament or a staff of Parliament and the clerk for that matter. So I think that we have there are a lot of gray areas. For example, if you say he is on his way to Parliament, suppose I get up 6 o'clock a.m. and then I take my bath in the house and then police come. I can say that I'm preparing to go to Parliament. Is that the same thing? That is while I'm in my house, but maybe that morning I'm going to court. And then maybe from there, if time still permits and Parliament is still sitting, I will go to Parliament, like some lawyers who have gotten permission to practice, or some other professionals, etc. But he will tell you easily that I'm preparing to go to Parliament. The question is, in the Constitution, it says he is on his way to Parliament. Is somebody who is in his house preparing to leave for Parliament, is it the same thing as he's on his way to Parliament? Okay. That is subject to several interpretations. Right. Somebody can say, well, it begins from your preparation towards going to Parliament. It's not just when you enter your car and you are driving and then moving straight to Parliament, but all the efforts that you make at home, the preparation that you make at home to send you to Parliament, you are on your way to Parliament. Then attending Parliament. Somebody gets to Parliament and then decides that, oh, the proceedings are boring. Let me go and then look for some matters for my constituency, or let me go to the bank and check my account and do some business and the rest of them. And he leaves Parliament and he's in the bank, or he's in the court filing, a lawyer filing processes, which has nothing to do with Parliament. But he's still in his suit, and then you come and arrest. He said, oh, I'm just in Parliament, I have just left Parliament, I'm going back to Parliament. And the police or the court bailiffs or clerks become stranded, or finally returning from any proceedings of Parliament. Right. That is very ambiguous. I'm returning from parliamentary proceedings. I'm going back home. I've finished Parliament, I'm returning home. And they say he cannot be served with a process and the rest of them. Right. I find these three elements to be very, very challenging. And then a challenge to law enforcement agents and to the judicial service. And even though we want to maintain the dignity of Parliament, we want to make sure that MPs are not fettered unduly when they are going to Parliament. I think that we have some challenges there that we may have to look at.
Great, we'll take a look at that. Honorable Osaichi Mensah, let me get your preliminary comments on this provision.
Well, I think that the language employed in the Constitution speaks for itself. It is said that criminal or civil process coming from any court or place out of Parliament, which includes the police and any other authority, shall not be served on or executed in relation to the Speaker of Parliament, the Member of Parliament, or the Clerk of Parliament, while he is on his way to attending at or returning from any proceedings of Parliament. As I said, the language speaks for itself. There is a history behind this, and it originates from capricious abuse of power in the UK when democracy was emerging. Let's not forget, the king at the time used to be the sovereign. Right. He wasn't to be challenged. And Parliament started as a forum to, as it were, challenge the authority, or so it was deemed, the authority of the king at the time. And so if people came to Parliament, immediately they finished, and it was deemed that we had said anything against authority, you could be waylaid and executed. Right. So this was to provide a cover, a protection for members of Parliament. And this provision does not only exist in our Constitution, you know, similar wording, similar construction in almost all constitutions of established democracies. It's about the same thing as the protection that we offer to our head of state, the president or prime minister, right? Now, the principle should be understood. The principle behind this is that the member of Parliament who represents a constituency or constituents, if we could have the resources to construct a large enough edifice to contain all of our citizens in this country, to participate in deliberations and decision making, that would be the ultimate. But it is not possible to have that, which is why representatives are chosen or elected, if you may, to represent constituents. Now, this clause or this article exists to protect the member so that ultimately, and by extension, the people that he or she represents would not be denied of representation in Parliament. They would not be denied of participation in deliberation in Parliament. But more importantly, when it comes to decision making, the people should not be denied of their right to participate in decision making. That's why we have these provisions. Indeed, if you came to Article 122, and I believe you perhaps may get there, right. 122 further provides that an act or omission which obstructs or impedes Parliament in the performance of its functions, or which otherwise obstructs or impedes a member or officer of Parliament in the discharge of his duties, or affronts the dignity of Parliament, or which tends either directly or indirectly to produce that result, is contempt of Parliament. So it is a clear-cut provision to ensure that a member in the performance of his duties is not obstructed or impeded. It's not, as it were, forced to attend to maybe a process in the court, or to respond to police interrogations and so on and so forth. So these are the things. But, as my colleague said, and I would say that by this provision, many democracies in several European countries, for instance, take cover under this. And just like the protection that is given to the president, who cannot be prosecuted while serving as the head of state, in many jurisdictions, members of Parliament cannot be prosecuted for the term of office, a particular term of office. Of course, the situation is this, where one person may just transition into another Parliament. He serves this term, and immediately the term ends, the day after, or perhaps continuously, he enters into another regime. So some people worry that can we extend this kind of protection ad infinitum? Sometimes the person, fancy the situation where maybe I get up, perish the thought though, I get up and I suffer heat in my mind. I pick up a gun and shoot my spouse. And strictly speaking, technically, I take cover under this. I think it would be overstretching the issue. And so, and yet, for any reason, somebody can take cover under this. The point being canvassed, however, is that when we talk about parliamentary business, it doesn't involve only plenary sittings. Committee meetings, group meetings. Sometimes it's not a committee, it's a group meeting. Maybe because we appoint or nominate from amongst ourselves certain members to participate in a workshop, in a seminar, right? It's not a committee. Majority leader plus myself plus the speaker have traveled to represent Parliament. It is not a committee, it's a delegation. But we are going to represent Ghana and transact business on behalf of Ghana's Parliament. So we have certain times that people do this on behalf of Parliament. All that is counted as part of parliamentary business. And it should also be understood that if a person is doing constituency business, it is because he's being elected as a member of Parliament. So constituency business, strictly speaking, is part of parliamentary business. So that if Parliament even goes on recess, and a person is at the constituency pursuing parliamentary business, he is deemed to be performing parliamentary business. Right. So the question is, can the person who perhaps has committed an offense eternally take cover under this? And that is why certain jurisdictions fashion their own way, so that even though these provisions exist, we develop a convention where, for instance, we may decide that Parliament closes at 2. Between 2 and 3, you are moving to your house. But because of the seriousness of this matter, the Speaker then says, we are veiling, the Speaker and leadership would say that we are veiling this person to the police or the relevant authority for interrogation, for questioning, for a statement that you require from him, or if he has to serve as a witness at any place, then that immunity will be temporarily waived, so to speak, to enable the person conduct that business. The point then is, because of the authority of the speaker behind the person will not be unduly delayed.
Okay.
Or
but what you're recommending means coming through the speaker, so to speak. Let me begin this segment with you and ask you. You have said that you think that there are practical problems here and there are some gray areas. But let's find out from you. How are you engaged in parliamentary business, so to speak, or proceedings of parliament, to use the words of the Constitution, Monday to Friday, ordinarily?
Well, there are various types of parliamentary business.
Right.
One, and what many Ghanaians know of, is sitting in the chamber and debating, or either on bills or loan agreements or instruments, whatever. That is, you are doing chamber work. Now, we also have committee deliberations, because the chamber work there will be no work in the chamber if committees do not prepare reports and documents for us to look at and then debate. So there is a lot of work at the committee stage. That is part of parliamentary business. There are also trips outside Parliament, maybe even outside Accra, for members of Parliament to involve in. There are trips to your constituency to investigate something, to collect some information, to assist you to debate, etc. You may even have to go to a region or to a ministry to be able to do research, or to a library to do research, to come back and debate. All these can be factored in as parliamentary business. But if you are not careful about them, it may be subject to abuse. There's no limit to it. So on Sunday, somebody once is at home, he said, "Oh, I'm preparing to go and meet my constituents in Medina or Teshi and whatnot to discuss some matters that that are in the order paper, which I want their opinion before I contribute to the debate." And you'll be stalled.
Can we call that proceedings of Parliament?
It's not proceedings of Parliament.
Because I'm looking at the Constitution.
Yes.
And it says, because you are dwelling a lot on the final part, where you say, whilst it's on its way to, attending at, or returning from any proceedings of Parliament.
That's right.
My question to you is, would you consider the last example you gave as amounting to proceedings of Parliament? That I'm looking at something in my house, and I'm going to meet some people down there at Medina and discuss with them. Can we call that proceedings of Parliament?
You may not strictly call it proceedings of Parliament, but it is preparation to enhance you to be able to participate effectively in the proceedings of Parliament.
So, but in itself, that one is not.
In itself, it's not proceedings of Parliament. It's not ipso facto proceedings of Parliament. But it is we have something like a Venn diagram. You have a universal set and the subset.
That's right.
The subset might be the proceedings in Parliament, but universal set will be the issues, the efforts, the preparations towards the proceedings, you taking part in the proceedings in Parliament. Like I said, if we don't prepare at the committee stage and bring reports, there will be no proceedings in Parliament. What are we going to debate? What are we going to look at? So if you bring a bill, they will refer to the appropriate committee. If the bill is on agriculture or is on education, they will refer to the education committee or food and agriculture committee. And then when they deliberate and bring their report and then present it to the House, then we can then have proceedings in Parliament. But at committee stage, it is also proceedings.
Let me ask you this quickly.
So it's a loose...
If you are home watching a movie with your family.
That's right.
And I'm sure you do that sometimes. Or watching a football game. The Black Stars play and we all watch the games.
Yes.
Whilst watching that game, if you are arrested, and I ask the same question of you, is that an affront to Article 117? Would you say that you have immunity at that time?
With the greatest respect, I think you have no such immunity. You shouldn't rely on Article 117 to prevent yourself from being served a process from the court or being interrogated by the police and the rest of them.
Whilst you're watching
at home relaxing and overstretching it. Otherwise, as I said,
or you go to the stadium to see a football game.
To see a football game.
Go to watch a boxing fight.
And then you say that, oh, from here I'm going to Parliament, or from here I'm going to a committee meeting, the rest of them. That would be an abuse of the constitutional provision.
It would be an abuse. So do you think that a parliamentarian can be arrested, served with a process, given the current situation we have at these other times, And I gather from what you said that yes, based on what you're doing,
it should be possible. And let's know that when a parliamentarian says that I am on my way to Parliament, or I'm from Parliament, or I'm doing this, these are questions of fact and not questions of law.
Okay, great.
And a question, you can pardon or exonerate an official, maybe who is having wanted to set a court process, or a security man who want to effect arrest on issues or questions of fact.
Okay.
I have seen you at home, returning from home, whether you were from the tennis club or a drinking bar, or you visited a friend, or coming from a committee where I will not know.
Or coming from this discussion.
Exactly, I will not know. So it is a question of fact.
Okay.
So if I attempt to arrest you, I'm initially justified.
Okay.
Unless you explain, and there's reason to believe in your explanation that in fact you are coming from Parliament or doing parliamentary work. That is where you can avail yourself of Article 117. But otherwise, it is a question of fact, and then it is in the peculiar knowledge of the MP who is a suspect or who is supposed to be dealt with, and he might be able to convince the fellow pursuing him that I'm actually coming from committee work or parliamentary work.
Honourable Minority, sorry, you finished?
That's right.
Honourable Minority Leader, can a member of Parliament be served with any such process whilst he remains a member of Parliament? If yes, when? If no, why not?
Well, it depends on how we interpret 117 and 122.
Right.
Even the question that you posed, that if a member is watching a football match, could it be said that is in any way engaged in parliamentary business? One could say yes, particularly given our circumstances where we don't have offices, right? You have a member of parliament who is sports inclined. Maybe he's watching the match to position him to perhaps contribute intelligently to a debate on football.
What about the one about a movie I gave? Because I gave 2 examples.
Yeah, absolutely. Absolutely.
Your wife and children.
Absolutely. The lessons to be learned in order for the person to be properly positioned to contribute intelligently from a very informed perspective in the following day. The business of the following day. I mean, somebody could justify saying on these lines. How do you disprove that the person is not doing that pursuant to that noble, intended noble enterprise?
And his example was a drinking bar. I'm wondering what the drinking bar will be contributing to tomorrow's debate.
Well, I don't know.
Well, after a hard day's work, to relax. That's after. After a hard day's work, to relax in order to reposition.
Yes. So the chain is broken. At that time, the chain of returning from is not broken.
Even here.
Okay.
We are here.
Right.
Why are we here?
Right.
We are doing parliamentary business.
We are doing parliamentary business. But Parliament is supposed to have closed officially at 2 o'clock as we did today.
Okay.
So somebody would say that, but you finished at 2 o'clock, 2:30.
Yes.
Right?
Right.
Perhaps if I had, normally, the two of us, we stay beyond 6, 7, 8. The earliest time that we leave the house it's about 8, 9 o'clock in the evening.
I see.
And normally I get to the office around 6 a.m. Normally I leave my house between 5:15 and 5:20 a.m.
Okay.
Because I have to get myself sorted out, I get up at 4 a.m. and I start preparation.
Okay.
So I'm saying that even this, one could look at it. A parliament, they say, is as strong as its committees make it.
Okay.
So committee work elsewhere is even more involving than plenary work.
Okay.
A person leaves because of the challenges that we have. Maybe he has to go to a decent library to look for relevant information.
Right.
One would say that, well, we finished, and 11 o'clock you are pursuing, also, I'm looking for this information. I want to do some comparative analysis. That's why I'm here.
Okay.
So one can always stretch this.
Right.
Which is why I have said that jurisdictions are now fashioning their own methods.
But please, before you do that, my question really was, is there ever a time is there ever a time in the life of a member of parliament, for example, where you believe that he or she can be served with such a civil or criminal process coming from any court or any authority? Is there ever a time in
I cited an example about maybe somebody shooting a spouse.
Right.
And I said that it should be possible.
Okay.
Right? Notwithstanding this.
Okay.
Because my understanding of this is that if the person does anything in his official capacity, shooting my wife perhaps cannot be linked to my official business. And yet you may get somebody who would say that, like we are here today, at this hour, if my wife were to be around, and sometimes when she comes down and I overstay, she will say, tomorrow I'll be with you. And maybe I have to leave at 11 p.m. Because she's with me, maybe I have to leave a bit early. Maybe between 9 and 10, we have to go home.
Okay.
Fancy a situation where you go home late. Your wife is so cross with you that she thinks that you were not in parliament. A heated argument ensues. In frustration, she attacks you, and then you pick up something. In self-defense, you push her. She hits the ground, and she transitions. You can be charged with manslaughter. A misunderstanding born out of your official work. So how do you stress this?
Yeah, and I'm saying it's still a criminal matter. At what point are you able to serve the process of that? Because the Constitution says criminal or civil.
Yes,
but
that is why I'm saying
criminal scenario.
That is why I'm saying that it should be possible. That is why parliaments devise their own means, such that you don't also surrender the dignity of parliament into the hands of law enforcing agencies, who then, if care is not taken, decide to act capriciously. It's capricious use of power which should be resisted. However, because we are members of parliament and we make laws for laws to be obeyed.
Okay.
And it should not be seen of us as making the laws for others to obey and we're refusing to obey them.
But Honorable, you wanted to make a point, yes.
To make some suggestions as to how we can beneficially handle Article 117 and its related articles.
All right.
I think that we should be able to differentiate between civil process and then criminal process. Right. The civil process is quite harmless in the sense that they bring you a statement of claim. Even if you are a layman, you would have to get time and pass it on to a lawyer to look at and then advise you and the rest of them. Sure. I do not see why that should be an inhibition that should be a problem about serving a member of parliament. Maybe we can avoid that when he's in the chamber, because you can distract his attention. Okay. But if he's at home or whatever, and not at parliamentary proceedings, so to speak, at the committee stage or in the chamber, he should be able to be served on that.
I won't cut you. Let me just ask him.
Yes.
Do you agree with that?
Well,
service of a statement of claim or something like that. I'll come back to him. I just want to get.
I'm saying that it's for us as a parliament to come to some determination on that.
Okay.
And perhaps we can find some middle ground.
Okay.
Because in jurisdictions where these things are allowed, they will say that because Parliament, for instance, doesn't sit on Monday.
Okay.
Can we set aside Mondays for this?
That was the reason I asked you about whether you do Monday to Friday.
Yes. Ordinarily,
we don't
Parliament doesn't sit on Monday. Ordinarily. Okay. So, but it's
today or tomorrow, do you think that a process can be served on a member of parliament? Because I'll come back to him to continue his point. I'm just trying to get your view on this before we proceed.
That's why it doesn't lie in my mouth as a person, as an individual.
Okay.
Indeed, today when the matter came up and the speaker threw it back to us, she added that we should act expeditiously within the next couple of days. Because you never know what somebody is planning tomorrow.
Okay, all right.
So that we set for ourselves our own standards.
Standards that you can follow. Honorable Advocate, sorry, but I just wanted,
that is one scenario. We should be able to liberalize or liberate the provisions to with regard to handling civil processes.
Okay.
Yeah.
Okay.
It shouldn't be so watertight like we have in the Constitution.
Okay.
The second leg is we should also differentiate between various types of criminal offenses. There's a felony and there's a misdemeanor. There's a very serious offense, like he was given an example, like you butcher your wife in the
those
room,
ones, things that carry death sentence, life sentence.
Yes.
Yeah.
So that serious case of that nature, felony, and more so, we should also be able to ascertain offenses that are committed and caught red-handed.
Okay.
I mean, you are an MP, you are driving, you run over a crowd of children on the road and the rest of them.
Right.
And then they come to apprehend you at that moment.
Right.
And then you plead immunity under the Constitution.
Okay.
That is absurd.
All right.
So the law should be able to provide that if you commit a felony.
Offenses in flagrante delicto.
Exactly. On the spot.
What about jumping the red light, for example?
Yeah, jumping the red light. Of course, this is a traffic offense.
All right.
It's a minor offense.
It's a minor offense.
It's a misdemeanor.
It's a misdemeanor.
Yes, I have another.
Oh, you come to that.
Yes.
You're dealing with the felonies
exactly,
now.
Exactly.
Okay.
We are dealing with serious felonies.
Right.
First degree, second degree felonies. And then more so, you are caught in the act.
Okay.
It's a felony.
Right.
You can cause murder or manslaughter, but you may not be caught in the act.
Okay.
They can detect that later.
Okay.
You should be able to waive some of these things because a citizen's life has been lost.
Okay.
You are alive and you are talking about liberties.
Okay.
What about the fellow whose life is lost? And the state has a right to protect that fellow's life. And they only want you to assist in investigations. And you plead all these things that we have in the Constitution. Yeah, so that's an area that we should be looking at.
Okay.
And then if it is a misdemeanor, like you talk about the traffic offense or assault and those matters and the rest of them, that do not follow up with injuries and the rest of them.
Right.
You can inform the member by phone, telephone, or we want to see you at your convenience this day and whatnot. And that should be permissible.
Okay.
We are able to differentiate between the types civil and criminal offenses in the first instance. And then the various types of criminal offenses, the serious ones, the felonies.
Okay.
Even first and second degree felonies and the rest of them.
Okay.
And you come to a misdemeanor.
Right.
Then we must fashion a way, like I have been talking. We must be able to fashion some guidelines as to how these types of offenses, etc., can be handled.
Okay.
We must balance, and it must be a balancing act between the rule of law in the country, which we all have vowed or taken an oath to defend and protect, vis-a-vis the right of the individual member of parliament, so we do not also unduly frustrate the business of parliament.
Right.
There is a history behind it, like he was trying to say at the beginning.
Yes.
He's a minority leader. Right. We are going to have a very serious debate tomorrow on some topical issue. They know he has strong views on the subject. So to be able to frustrate him from participating in the debate early morning, they surround the house and say that there's a warrant to arrest you or you are alleged to have committed this. That is an abuse. Right. That is clearly trying to subvert the course of justice or the proceedings in parliament. Okay. And I think that is what the Constitution wanted to avoid or to prevent. Okay. Or you are going to take a debate on a serious matter. They know that the way I argued, I'm going to vote against. Early morning, I'm the target to make sure that one number is dropped out or the numbers are balancing. They make sure that one or two people are picked so that the other side will have an advantage. I think it is because of these negative things that the Constitution wanted to avoid as a result of previous experiences either here or in other jurisdictions. But we might have gone too far in making these provisions. And then we now make, I'm playing a devil's advocate. Right. We now make a member of parliament so immune that at the end of the day, the ordinary man on the street will say, is that justice? I vote for somebody, and the fellow takes the law into his hand, or he does this, and the law cannot bring him to book. I'm taking 3 months, 6 months. I can't serve him with a civil process or a criminal process because every other day he's doing a parliamentary business. I think this is a challenge. So we made a statement today, he and minority and myself, that then we must fashion a way.
The ad hoc committee and all that.
Trying to address this thing.
Okay. I'll ask the Honorable Minority Leader, but let me take some messages while our viewers feel a part of the show about how we balance contempt of parliament vis-a-vis contempt of court. And how do we make those things work? For example, the court issues a bench warrant, and then they say, well, we can't serve it because it's Article 122, which you cite and all that. Would that amount to a contempt of parliament? What about contempt of court, and how do we deal with it? Can a member of parliament be arrested without the permission of the Speaker of Parliament? If yes, Then what if he's found shooting at a marketplace? Please ask the Honorable Minority Leader for me. You didn't add your name. I think he has addressed that, particularly with relation to killing somebody and all that. But can a member of parliament be arrested without the Speaker of Parliament? Are we able to get a quick answer to that before I move on to some other messages?
Yes, let me say this. I indicated that normally practices evolve and they become conventions.
Right.
But you see, Article 118, 2, we are talking about, 117 talks about a member on his way to attending at or returning from any proceedings of Parliament.
Right.
Now, if you look at Article 118, 2 says, the certificate of the Speaker that a member or the clerk to Parliament is attending the proceedings of Parliament is conclusive evidence of attendance at Parliament. That is why speakers are drawn into the fray, because you need the certificate from the Speaker to indicate to the court or the police that the person is attending at the business of Parliament,
yes,
in committees or wherever, or is in any way involved in the transaction of business on behalf of Parliament.
And this is immunity from witness summons, 118.
Yes.
It's immunity from witness summons.
No, what it flows from 117.
It does, but you realize that 117 is immunity from service of process and arrest. It's 117.
Yes.
And 118 is dealing with, it says neither the Speaker nor member of nor clerk to Parliament shall be compelled while attending Parliament to appear as a witness in any court or place out of Parliament.
Right.
So 118 is limited to service as a witness.
The point I'm making is that I'm talking about how the Speaker gets involved.
Okay. All right. And I'm wondering why the Speaker's involvement tends in the Constitution to be limited to service as a witness and not any other thing else.
That's why I'm saying that elsewhere, in fact, the language is about the same in all constitutions that I know.
Yeah, the Commonwealth constitutions generally.
The Commonwealth constitutions generally.
Yes.
And it is applied to all other instances. Right?
Right.
One will ask, why to members of Parliament? Another person will ask, why even to the head of state, the president?
Right.
We are Ghanaians. And I'm saying that it's not for nothing. Because you vote for the president to achieve a purpose for the country within a given time. And then people start serving the president with warrants and so on, and compelling the president to attend to court proceedings and so on and so forth, to distract his attention from matters for which he's been voted into power. So it's for a purpose that these things are provided. But as I indicated, it's important for us to look at this, do serious introspection.
Right.
What could we do? Sometimes some jurisdictions provide that during their long recess, they have a rest period.
Okay.
The rest period, maybe they will say about 2 weeks. You are to reinvigorate. Some would say that at that time, if there's anything, the member could then be released in quotes.
Okay.
But because ours is a continuing Parliament, if you stretch it, you would say that any person can take a cover under these provisions at any given time. Which is why I'm saying that I don't, however, think that kind of, if you like, ring fencing should be eternal. There should be an opening such that members will live up to their responsibilities. But we will have to craft something.
Right. Thanks. Let's take a few more messages as quickly as we're able to. Dixon Desiree in Laura says, no member of Parliament should really be above the laws of the state. But the arrest of Mr. Obiamwa is just a shame. The NDC should give us a break. Ghanaians are tired of them. All right. Ignatius Kofi Amaglo says, the vagueness and ambiguity of Article 117 has portrayed MPs as gods who are untouchable. So long as the law is supreme in our thriving democracy, this provision should be reviewed as soon as possible. However, the MPP should stop assuming the know-it-all posture and allow the state institutions to carry out their duties in the interest of the nation. David in Sandema, if a member of Parliament is caught carrying cocaine and he says he's on his way to Parliament, should he be left to go free when all evidence show otherwise? Don't your panelists think that it creates room for MPs to abuse the law? All right, let's go on to the next one. Okay, I've read this already. Let's move on. Tini Iyadema says, let's get this straight. They can be dealt with by the law enforcement agencies like any other citizen. Nobody should be allowed to hide behind the constitution to commit crime. Remember Ghana first. Good evening. Good evening to you as well. Bawa Mohammed asks, why is Article 117 there to protect NPP members of parliament alone? Okay, I think what you mean is why? Yes. Is Article 117 there to protect NPP members of parliament alone? Yeah. No. They should cooperate with the security agencies and stop seeking for the truth on the airwaves. All right, Bawa. Another says, did the article in question refer to the member of parliament attending to parliamentary business or proceedings of parliament? Of course, as we said, proceedings of parliament. It says, which is which?
Proceedings of parliament is business of parliament.
Absolutely, because his question is, which is which? Are these two the same?
The same.
The answer you are getting is that the two are the same. My good friend, you don't add your name anyway. Yaya Isa, MPs are not above the law. Therefore, if they abuse the law, they must be dealt with and they must be made to face the law. Sir Kodia in Kumasi, I think due process must always be adhered to with regards to MPs' conditions and not flouted with impunity. Nevertheless, Nana Addo has proven to be a good leader who believes in wealth creation through job creation. Okay, sir. Thank you for giving us a new topic for tonight. You know, we're discussing something else. Richmond Sunkwan says, no one is above the law. A member of parliament must be arrested only if he has actually offended the law.
You don't investigate. How do you know that he has actually offended the law?
Interesting. All right, we've read this. Be guilty, no, you represent. Okay, Dixon Desiree, I think you sent another one. I think no one should be really above the laws of the state. But if a figure like an MP is to be arrested, it should be done with some sense of dignity and respect, since he may be guilty or not. Yeah. He represents a whole lot of people. Thank you. Enoch Ben Saki says, I think MPs are not above the law. They can be arrested, but not within their functional hours, unless it is so ordered by the speaker. Lord Incarnation, where was okay, all right, that's okay. I think it's something else you send, and I will not be reading that. Dixon Desiree again, no member of parliament should really be above the laws of the state. Okay, you've sent that already. Let's come back to the studio. We have just a few minutes to run out of here. But Honorable Minority Leader, you called for an ad hoc committee, and from the reports I have monitored, you support this, even though I'm told that there was some shouting at you, so to speak, shouting in inverted commas when you proceeded to explain what you meant. How do you want this committee to work, and how do you expect it to find the results that will be satisfying or pleasing to everybody across the divide?
See, first of all, I think Article 117
yes
should be read in tandem with 122.
Okay, in general contempt.
Yes, general contempt. And it provides that an act or omission which obstructs or impedes Parliament in the performance of its functions, that is the prescribed functions of Parliament, or which obstructs or impedes a member or officer of Parliament in the discharge of his duties, that is the duties of that person as a member of Parliament. So we should define the general parameters. What indeed are the duties of members of Parliament, right? Such that if you involve yourself in this and, you know, something ensues from it, which perhaps causes disaffection or damage to another person, for which the person may have to respond, right? Then that person, we ourselves should establish those parameters. And then the days and hours are something that we can dialogue on, right? As leadership, and of course with that committee by us, come to some determination. We will then throw it up to members of Parliament. And then when we have so defined for ourselves the no-go areas, one, and then two, the hours, the days and hours during which members may, as I said, be released to respond to investigations or to appear before the court. And subject themselves to due process. I think we can come to that determination. And I believe it shouldn't be too difficult. I think in this particular case, what we're concerned about is the modus of arrest. It is not what really, we are not dealing with the substance of the matter, right? It's the modus of arrest that we are concerned with. And I think that should be our concern for the time being. And I think with goodwill on all sides, we can come to some general agreement in the shortest possible time.
Honorable Cletus Avoka, your final words.
Yes. I think that there must, we should be able to involve the speaker and the leadership in this process.
Okay.
And as I indicated earlier, there are two processes that the Constitution provides for: the civil processes and then the criminal one.
That's right.
With the civil process, it should be possible for them to come and leave the document with Madam Speaker, and then Madam Speaker will inform the leader, the caucus leader of that particular MP, that there is a court process for you, or you are invited for this and this and that, and then we'll make the fellow available to be served and whatnot and whatnot. That one is civil. That's civil. Right. Now with the criminal one, there are two aspects of it: the felony and then the misdemeanor. Right. With the misdemeanor, it should be easy. You can pass through the speaker again. An MP is wanted for ABCD purpose. The speaker will inform the caucus leader. If it is a member of the minority, inform the minority leader. If it is a member of the majority, inform the majority leader. This fellow is alleged to have done this, and they want him at this time or at this convenient time. Right. The leader and the speaker will know the convenient time and urge the member to avail himself for that process. Okay. With regard to the felony, I think that the law must take its own course. Okay. If you are involved in a violent felony, and more so the felony, you are caught red-handed, there's no justification for you to go and report to somebody before you arrest such a fellow. Okay. You should deal with the fellow directly.